A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. Welcome to another edition of Bearing Arms, Cam & Company. My name is Cam Edwards. Glad you're with me on the program today. Should have turned off my cell phone before we started the show, but there we go. Kostas Moros is going to be joining us here in just a moment or two. Second Amendment Foundation's Director of Legal Research and Education. We're going to be talking about the latest in a series of attacks on stand your ground laws coming from the Wall Street Journal. This has been really weird. You know, we think of the Wall Street Journal, and maybe the editorial page is pretty conservative, but the paper itself, certainly, as we've seen over the past couple of months, when it comes to our right to keep and bear arms, taking a very, very liberal stance. So the first piece that they ran was claiming that essentially stand your ground laws were letting people get away with murder. I think the headline was like, the 6 words you need to know, right? And it was, I was afraid for my life. That was basically the gist of it. If you say that, then by God, you're never going to be charged with, murder, which is not the case. Then they followed it up with a piece on, I think it was Tallahassee, Florida, and the number of justified homicides in that city. Not since Stand Your Ground took effect in Florida 20 years ago, but only like over the past 5 years. Really weird. And again, the insinuation was that people are getting away with murder, right? I got to say, though, the anecdotes that they provide, the incidents that they talk about, there was one case that was maybe 50-50. The other cases, though, it was pretty clear that these individuals were defending themselves against violent aggressors. And in my opinion, the facts of the story did not match the headline and certainly did not match the tone of the story. And then over the weekend, we saw another piece from the Wall Street Journal talking about innocent bystanders who are shot when somebody is acting in lawful self-defense. And the fact that in most states, someone who injures or kills another while they're acting to protect themselves is not, they're not subject to criminal charges. And again, the insinuation is there's something wrong with that, right? Also, another insinuation that this seems to be happening more in states with stand your ground laws, although they provided no data or evidence to back that up. In fact, they provided no evidence or data to suggest that the number of individuals, again, innocent bystanders who have been shot or killed by someone acting in lawful self-defense have increased over the past few years. They kind of reference permitless carry laws, but of the 3 incidents that they talk about, only 1 took place in a permitless carry state. Again, it's just very odd reporting. And I'm not really sure what the angle here is other than to rile up opposition to stand your ground, to permitless carry, and to self-defense in general. Kostas Moros had a pretty good rebuttal on X after this story appeared in the Wall Street Journal, and so I invited him on to talk about that. I also want to get Kostas' thoughts, though, on what's going on at the Supreme Court regarding our right to keep and bear arms. So without any further ado, let's kick off the conversation. Take a look and a listen. Kostas, thanks so much for coming on the program. It's good to see you again.
Thanks for having me on, Cam. Always a pleasure.
And, I feel like I see you all the time, actually, because I follow you on X, even though I'm not an active participant all that much. And, you had such a great response to this latest Wall Street Journal article. One, as I mentioned in our introduction here, one of I guess we're up to 3 parts of this continued attack on stand your ground, permitless carry. It's kind of throwing the kitchen sink at gun owners here. This first one, again, was the 6 words you need to know to basically indemnify yourself from being charged with murder, right? Claiming the stand your grounds, allowing people to get away with murder. Then they took a look at justifiable homicides in, I think it was Jacksonville, Florida. And again, insinuating that people are getting away with murder. And then this latest piece is about innocent bystanders who are shot and killed when people are acting in lawful self-defense. And, the idea, at least I got the impression, Kostas, that the gist of the story is, boy, it's really too bad that these people can't be charged with something, even though individuals can be charged in a lot of states, depending on, how reckless their actions may have been. but also that these things are really rare circumstances, right? And yet this whole idea is kind of denigrating the idea that people should be able to or need to act to protect themselves at times.
Yeah, I think what struck me about the article, we had a heads up it was coming because they asked staff for comment and they included our comment. But I figured, they didn't tell us what was going to be in the article other than some generalities. But what struck me about it reading the final product was it just used 4 anecdotes. It didn't cite like, oh, these are 4 anecdotes, but we have all these other cases. Here's a database we made you can look at about how. So I'm left to conclude that there might have only been 4 of these that they could find. Maybe there's a couple more, but this just proves how rare this is. And, it's obviously, you should practice. You shouldn't, it's not okay to hit an innocent bystander. Everyone knows that. But these are people foisted into like the worst day of their lives. They're not professionals and they're defending themselves. And yes, unfortunately, sometimes this kind of thing will happen, but it is exceedingly rare. You have thousands of self-defense cases a year. And this Wall Street Journal writer, and it is the same writer across all these articles, he found 4 such incidents. And 2 of them, by the way, were in states, California and Massachusetts, which are very strict on issuing permits. So it's not as if, you can claim this because of permitless carry like the article kind of does, strangely.
Right. Yeah. Well, yeah. I mean, they kind of throw out stand your ground. They kind of throw out permitless carry as, and then again, they suggest that these incidents are increasing without providing any evidence to that effect whatsoever. As you say, there's no hard data at all in this story. It is entirely based on those 4 incidents that they relate. And I think only one of them was actually in a permitless carry state. It was in Ohio. But even then, the incident in question took place at a business. And generally speaking, if you are employed by a business or you own a business, you don't need a carry permit to carry on the premises of that business, right?
That's correct. And it threw out the permitless carry and stand your ground thing because it quoted a gun control group. I think it was Everytown saying, as we see the rise of permitless carry and this and that, this is going to happen more. But the headlining example it used was from Massachusetts, which is neither permitless carry nor stand your ground. And in fact, they charged that guy with murder. And the whole article, I guess, was inspired because the Massachusetts Supreme Court said, no, he's not guilty of murder. You can't you can't put him in jail for that because he was defending himself. And it was actually the criminal who precipitated this incident. There's a doctrine called transferred intent. So the criminal is actually liable here by precipitating the incident. But one thing the article didn't cover, it only mentioned it in passing, but it's kind of a critical difference, is that gentleman in Massachusetts now is going to be sued or might already be being sued civilly. He can be liable for civil damages from the family, and they might win, and it could bankrupt him, And one distinction I think the article should have noted, and it didn't, was that when police shoot someone by mistake, they can't even be sued civilly because of qualified immunity. And I'm not even saying that's a bad thing. Sometimes it makes sense. If you're an officer trying to do your job, crazy situations happen. Maybe you accidentally shoot someone, God forbid, and you shouldn't be bankrupted because some criminal who's shooting at you got you into a gunfight and you screwed up. But in an article about accidental shootings, it's pretty crazy to not mention the police at all, especially when there's way more documented incidents of the police. I think I found LAPD had 21 of these sorts of shootings in a decade-long period. That's just one department. I know LAPD is large, but that's just one department. This guy found 4 nationwide, and he's trying to make it a big issue. I think it was an incredibly dishonest thing to do.
Absolutely. And correct me if I'm wrong, but the Massachusetts Supreme Court decision said that, okay, you can't charge this guy with murder, but they did say you could charge him with a lesser crime if prosecutors believe that he was acting recklessly, like manslaughter. I thought the Supreme Judicial Court said that would be an option going forward. And again, that's the case in many states, right? If you act in self-defense and you shoot an innocent bystander, okay, again, the transferred intent, right? It's the criminal who created that situation. But if while acting in self-defense, you acted recklessly with wanton disregard for others around you, you very well could end up facing charges for your actions.
Yes, yes. So they didn't so much. I would need to go back and check, but I don't believe the court said the government should do that. What they said is that we haven't closed that door.
Right.
You know, if you can show that he acted recklessly. That said, they haven't charged him yet. Maybe they will because it's Massachusetts and they hate people defending themselves. But as of now, they haven't charged him, and maybe the prosecutors there don't think they have a case for him acting recklessly. You know, when someone shows up and pulls a gun on you, it's not reckless to want to fire back.
Right. Yeah. Yeah. Well, and one of the cases that the Ohio case that was brought up in the story, the woman who shot another patron of this convenience store as she was being attacked by an individual, she was charged, I believe, with manslaughter. She was acquitted. Case went to a jury. She was found not guilty. And again, you've got to respect that judicial outcome. But I'm trying to figure out what's the angle that the Wall Street Journal is playing at here. And we've got stand your ground laws either, enshrined in statute or enshrined in common law in 38 states, 40 states?
Yeah, it's as many as 40. I forget. It's basically the Northeast and one or two other stray states that don't have it. All the West has it, including blue states. It's not just a Republican thing like they try and imply in these articles. I don't know. The author, he's written a series. The first one he wrote back in the spring was about self-defense insurance and how that's dangerous. Then he did the Stand Your Ground one, and now he did this one. And it seems like he just has an axe to grind against carry in general, and he's trying to create this impression that it's super dangerous, and these people are all unhinged lunatics who might start shooting at any moment. And when they do start shooting, they're going to be protected by these Stand Your Ground laws and self-defense insurance. It's nonsense. The data does not back this. And as I said in my response to it, which I sent to the Wall Street Journal, but don't hold your breath on them publishing it. But as I said in my response, the CDC actually tracks unintentional homicide data, including unintentional homicide by firearms. Now, that number does include accidental shootings in the home. It's not just these crazy incidents with a bystander getting shot.
Right.
But what that data shows us is there's actually 100 less of those. It's fallen from 550 to about 450 in the last 5 years. So unintentional firearm deaths are actually falling right now, not increasing, despite this expansion in carry rights. So the whole premise of the article, when you look at the data, is just false. These anecdotes are terrible, and nobody wants to see innocent bystanders get shot, but it's creating this very misleading impression in the reader. So.
Absolutely. And of course, you talk about the decline in accidental shootings, which is fantastic to see, but we're also in the middle of a historic decline in violent crime overall, right? Which, again, this is coming with the expansion of the right to carry, with Bruin, with additional permitless carry states. Many states, and in fact, the United States, I believe, as a whole, is on track to have the lowest homicide rate since the FBI started keeping track back in 1960.
Yeah, that's correct. And, when Bruin came out, and this was also when a bunch more states were passing permitless carry in addition to Bruin coming out. So we got these apocalyptic predictions from the gun control groups that, there's going to be blood in the streets, homicide's going to surge immediately, all this crime's going to happen. And not only were they wrong, it went in the opposite direction. Instead of crime surging, we've seen homicide and murder dropping to possibly record lows. Some city, Philadelphia had like 500 murders in 2021. Now it's going to have under 200 this year. So, or maybe just above 200. Point is, it's a huge, huge decline.
Yeah.
And that's repeated across many, many cities. So they were just so comically wrong. And not one of them has come out and admitted it and tried to explain why. And for the record, I can't sit here and claim it was carry rights that made murder drop. I can't prove that. Right. I think it might definitely have helped because it's a dissuading factor for criminals if there's a general knowledge people might be carrying. But the point is, at minimum, it did not stop the murder rate from dropping to record lows. So that's an important data point.
Absolutely. And one I think we're going to have to keep hammering home because, unfortunately, there are going to be media outlets like the Wall Street Journal that will either downplay or ignore those facts entirely. All right, before we let you go, Kostas, I got to ask. So Supreme Court orders list comes out Monday. No action on any Second Amendment case. They are relisted, I think, the ones that were up in conference last Friday. That includes Duncan versus Bonner. It includes Viramontes versus Cook County, which is a challenge to Cook County's ban on so-called assault weapons. You got another magazine ban case in Gators Custom Guns. A couple of prohibited persons cases. There are several other cases that are scheduled for their first conference this Friday. including a couple of NFA challenges. Supreme Court's already taken 2 cases this term. There are some critically important issues outstanding. I mean, we've got 4 cases dealing with the right to keep bear arms for adults under the age of 21 that Supreme Court hasn't resolved. They haven't, dismissed those cases or rejected those cert applications, but they haven't discussed them in conference or scheduled them for conference anymore. So those are just kind of off in their own little limbo. Where do you see the court going in terms of 2A cases for the rest of this term? Do you think we're going to get maybe a 3rd cert grant, maybe a 4th?
I've had people ask me this. I have to say I don't predict it happening simply because we've never had 2 cases before. So are we really going to get 3? But then again, I also said after the Wolford grant, we're not going to get a second one because we've never had more than one. So who knows? Maybe the Supreme Court is finally saying time to start settling some of these issues and they will grant another case or 2 other cases. But more likely, I think what's happening here is a lot of these cases are being piled up for GVRs where applicable. That's not the hardware cases. The hardware cases are separate. But you have all these 922G petitions with prohibited people. I see all of those being GVR'd after Himani. I think in Himani, they intend to give us some more guidance on when and when not you can bar someone from owning firearms. And then they'll GVR all these cases for more in line with that. Similarly, the carry cases, I think, for example, a Second Amendment Foundation, we have a petition right now in Schoenthal v. Raoul, which is about public transit in Illinois. I see that totally getting GVR'd for Wolford after, unless the court decides to keep Wolford as narrow as possible. I could see them giving more guidance on sensitive places. The big question, though, is these hardware cases. There is a couple of those criminal SBR cases. We did amicus briefs in those. But it remains to be seen. Justice Kavanaugh said they will deal with this issue in the next year or 2. Is it going to be a year or 2? That's pretty important right now for these pending cases, including Duncan and others. Duncan got relisted for the next conference, as did a bunch of others. So far, the only ones that have been denied are some 922G petitions. I think 4 or 5 got denied. But those were the cases that were most clearly about violent criminals. There's always people petitioning. So they're leaving the other ones to survive for now. And I think they're going to get GVR.
I got to correct you on one of those, because one of those cases that they deny, they
really
denied 2 Eighth Circuit cases, one of which in the Eighth Circuit, says you got to have this individual finding of dangerousness. In one of those cases, the district court went back and said, yeah, this guy's dangerous, can't own a gun. But in the other case, it might have been Baxter. The district court said, no, this individual's not a danger.
They denied Baxter. I missed that. Okay, my bad. Then there goes my theory. Then I have no idea what they're doing.
Well, I'll tell you, my theory is that they're leaning towards adopting the Eighth Circuit's argument. And that's why they let both of those Eighth Circuit cases, they declined cert in both of those cases, even though they had different outcomes. One case, guys continue to be a prohibited person. The other case, guys not. Again, that's just my theory. It could be completely unfounded. I guess we'll wait and see what's going on. But I think you're right in general, though, about the 922 cases. I think most of those are going to be held over until we hear what the court says in Himani. I hope you're wrong about Schoenthal versus Raoul. I'm going to be talking about that a little bit later on in the program. And this is just the issue of public transportation bans is so important because it deprives people of their right to keep their arms throughout the entirety of their day if they were dependent on public transportation, right? And, the Duncan case, as you well know, that's critically important too, because if the Supreme Court denies cert in Duncan, correct me if I'm wrong, but that means that the entirety of California's mag ban can be enforced, including those individuals who lawfully purchased magazines, but then were told by the state of California, you can't possess them anymore, right? So, I mean, there's no grandfather in California's mag ban anymore.
I'm one of those people. We'll either have to turn them in, take them out of state, destroy them. But the point is, I'm sure California will do what it typically has done in these prior situations, which they'll probably say, you have 90 days to comply, get them out of state, do whatever, and then you're out of luck. And the frustrating thing is, you have Justice Kavanaugh saying, we're going to deal with this in the next year or 2. But that's pretty incredibly disappointing if they were to deny Duncan only to redeem our rights a year later after we've lost all our magazines. So our amicus brief made that point. I think we told the Supreme Court in our amicus brief, look, we want you to grant Duncan, but if you don't grant Duncan, just hold it indefinitely. Don't send it back down. Just put it in, I think you called it limbo, whatever. Just leave it there until you do decide a hardware case, because otherwise the mandate will go into effect and we will be irreparably harmed in California with all these magazines. So I hope that weighs on them, but this is the Supreme Court, and they have lots of people telling them their case is super important. So we'll see if they agree.
Yeah, absolutely. Well, we'll play the waiting game for another week. Hopefully we'll get some good news next Monday. But as always, Kostas, really appreciate your insight. Thank you so much for all of your activism and your work. And look forward to doing this again very soon.
Thanks, Cam. Always a pleasure. Have a good one.
Kostas Moros from the Second Amendment Foundation joined us here on Bearing Arms, Cam and Company. My thanks to Kostas for joining us on the program. Always appreciate his insights. Before we get to today's Armed Citizen story, good deed of the day, and our recidivist report, just a reminder that the voting in the Gundies continues through the 15th, I believe. So you have until Sunday to go to thegundys.com. Cast your vote. I think there are 11 different categories. Vote for your favorites. I'm not going to pressure you to vote for anybody in particular. I will note that Bearing Arms, Cam and Company is up for Best Podcast, so we certainly would appreciate your vote. And I got to tell you, I mean, I'm so torn because the best two-way writer, we got John Petrolina, we got Tom Knighton, both of whom, contribute mightily to the work at Bearing Arms. So I would encourage you to vote for one or both of them, maybe alternate your votes. But just go to thegundys.com, cast your vote. You can do it every day, one vote per day. I believe you actually might be able to get extra votes if you watch a video or something like that. But anyway, thegundys.com. We certainly would appreciate you supporting the work we're doing here at Bearing Arms with the Gundies. All right. I don't have any cool videos or anything like Mark Smith from Four Boxes Diner. Just a heartfelt message. That's it. That's all I'm doing. All right. On to today's Armed Citizen story, our good deed of the day, and our recidivist report. Let's start there with a case out of Florida. Man on probation arrested for burglary, battery, and robbery. Now, as it turns out, this guy, well acquainted with the legal system, and appears to have caught multiple breaks along the way. 23-year-old Joseph Harold Wiggs was arrested early Monday morning for allegedly grabbing a man's phone, damaging the victim's car, hitting the victim, and preventing the victim from calling 911, according to the Alachua Chronicle. Wiggs took off running, but police located him at his home, where he initially denied knowing the victim, said he'd been home all night. Later reportedly changed his story, said that he had met the victim to talk, that they got into an argument, but nothing physical happened, saying he just walked home after the argument. After he was read his Miranda rights, he reportedly said that the victim hit him during their argument, so he walked away, denied snatching the victim's phone, denied hanging up the 911 calls or damaging the victim's car, which was a Tesla. After he was told that Teslas collect surveillance video, he then reportedly admitted to taking the phone, but say he had picked it up from the center console of the vehicle, said he left, but returned to give the victim back his phone, still denied hanging up the 911 calls, damaging the car, hitting the victims. Okay. As the Alachua Chronicle reports, Wiggs is a violent felony offender of special concern. That is a official designation in the state of Florida, who is on probation for threatening to shoot a woman as well as kicking a police officer. He's currently been charged with preventing communication with 911 services, burglary of an unoccupied vehicle, robbery by sudden snatching. I didn't realize that was a particular crime in Florida, as well as battery. The Alachua Chronicle notes that he has 3 previous felony convictions, all violent, and 2 misdemeanor convictions, 1 violent. Judge Susan Miller Jones set bail at $180,000. So I wanted to do a little bit of digging. He's on probation, apparently, for threatening to shoot a woman and kicking a police officer. He's 23 years old. So I wondered, okay, did he get any prison time at all? I found an earlier story from the Alachua Chronicle. This was from April of this year. Headline, man on pretrial release arrested for threatening to shoot woman and kicking police officer. So Wiggs was already on pretrial release when on April 8th he allegedly choked his girlfriend, someone who described as being in an on and off dating relationship with Wiggs. Allegedly took out a handgun, put his finger on the trigger, pointed it at the victim as she drove when they were in a car together. Allegedly threw objects at the victim, hitting her all over her body, threatened to hit her Victim later told a responding Gainesville Police Department officer that at one point she was able to pull the car over and get out, but Wiggs pointed the gun at her, told her to get back in, so she did, in fear for her safety. As we go further down into the story, we learn that back in April, Wiggs was charged with aggravated assault with a deadly weapon, false imprisonment, battery on a law enforcement officer, battery, possession of less than 20 grams of marijuana, and resisting an officer without violence. The Alachua Chronicle noted that he had a juvenile conviction from 2020 and one adult misdemeanor conviction. Now, again, that was in April of this year, right? He was also arrested in June of, and we now know he has got 3 felony convictions, 2 misdemeanor convictions. So apparently between April of this year and now, he's racked up 2 more felonies and a misdemeanor conviction, and apparently no prison time whatsoever. He also was arrested in June of 2024 for threatening to shoot a family member and placing a gun within reach of a child. Those charges were dropped. And then a sworn complaint was filed against him in February for choking a different woman. Those charges were also dropped. And then in March of this year, he was arrested for domestic battery and was released on $2,500 bail. That might account for one of the additional convictions that he has obtained since April of this year. And again, despite all of that, it appears that Mr. Wiggs has never been sentenced to prison. That all of these violent crimes that he has committed have ended up and been convicted of, not to mention the crimes that he was accused of and the charges were dropped, but the crimes that he has been convicted of, all violent felonies, except for the 2 misdemeanors, one of which was violent as well. And not one of them has resulted in this guy doing any time behind bars. The regularity with which Mr. Wiggs has been arrested and the serious nature of the crimes that he's accused of committing beg the question, what the hell does it take to go to prison in Florida? Or at least in Alachua County. So we'll continue to keep our eyes on this story. Maybe this is the offense that sends Mr. Wiggs to prison, but at this point, I'm going to hold my breath. On to today's armed citizen story. Now, this is an odd one. In fact, this is one of the few cases that I've discussed here on Cam Committee that may not actually be a case of self-defense. It's unclear at this point. Pine Bluff, Arkansas. Police investigate an incident where a man was shot after allegedly stealing a gun. So, according to KARK, which is the NBC affiliate in Little Rock, it was about 11 o'clock Sunday morning. Officers with the Pine Bluff Police Department called to a home regarding a report of a man being shot. When officers arrived, they said they spoke to a resident of the home who told them that she saw an unknown man inside her vehicle through her home security system. She told officers that when she went outside to confront the man, she discovered that her pistol had been taken from the driver's door of that vehicle. And then she told police that while demanding the man return the firearm, 2 shots were fired, not by him. We don't know who those shots were fired by, but 2 shots were fired that struck the man in the left neck and shoulder. Man reportedly then fell into a ditch, reportedly admitted breaking into the vehicle and taking the gun, and then took off running. Police report that the stolen firearm not recovered at the scene. Officers say a short time later they were dispatched to a different home regarding a male who reported being shot. When they arrived at the scene, they found a person who they say matched the description of the robbery suspect. He was taken to a local hospital. Police say he was not able to provide a statement due to medical intervention. Police are asking anyone with information to contact the Pine Bluff Police Department. So, again, like, who shot the guy? This may be the biggest mystery since Who Shot JR on Dallas way back in the day. It doesn't sound like it was the woman who confronted the man breaking into her car who had allegedly taken her gun. Was there an innocent bystander nearby? Was there a interested armed citizen? Was there another individual in the house who saw what was going on and shot the man to protect the woman? Again, we don't know. Presumably, this was not an act of self-defense because the news report doesn't say anything about the woman shooting the guy. But this may very well have been an act of defense of others right? If an individual believed, whoever fired these shots, believed that this guy posed a threat to that woman. As I said, it's a confusing story, and hopefully we do get more information and more details. But I just wanted to throw it out there, in part because of the unusual nature of this incident. All right, finally today, our good deed of the day, in the right place at the right time, willing and able to do the right thing, even at personal risk to himself. A North Carolina man who was stabbed by an illegal migrant on a train in Charlotte, who authorities say was a good Samaritan who was just trying to help others. Remember, this is 4 months or so after that woman from Ukraine, Irina Zarutska, was stabbed to death on a train in Charlotte. So this incident happened, I guess it was last week. Kenyon Doby, he's 24 years old, was on the train Friday night. Bunch of people, other passengers there. There's a guy named Oscar Solorzano, who police say was drinking alcohol on the train, yelling at riders. Doby stood up and told him to stop, at which point Solorzano is accused of whipping out a knife and stabbing Doby in the chest. Now, Doby is, at last report, in critical condition. He is able to speak. He's actually got a GoFundMe going to help raise money for his medical bills. As for Solorzano, the New York Post reports that he had previously been banned from the light rail system, which was just part of a, quote, long rap sheet for Solorzano that includes multiple arrests, a robbery conviction, and 2 deportations. Assistant Secretary of Homeland Security Tricia Lockwood said Solorzano had been deported from the U.S. twice before, but illegally returned to the country again for a 3rd time. She wrote on X, his criminal history includes prior arrests for aggravated battery with a deadly weapon, destroying evidence, resisting arrest, using a false ID, and convictions for robbery and illegal reentry. He's now been charged with attempted first-degree murder, assault with a deadly weapon, causing serious injury, breaking and entering, carrying a concealed weapon, and being intoxicated and disruptive, and is being held without bond. It is also important to note that Charlotte's light rail system is a gun-free, actually a weapons-free zone. So it doesn't matter if you have a concealed carry permit. You are not allowed to bring a gun onto a train to protect yourself from guys like Mr. Solzarno. Repeat offenders, violent offenders, who have no qualms about breaking the light rail's policy on not bringing weapons on board the trains, right? You're utterly defenseless, at least if you want to abide by the law. And if you were to use a firearm in self-defense, let's say you choose to violate that policy, right? Better be judged by 12 than carried by 6. Well, you probably are going to get judged by 12 because you too could be charged with illegally carrying a concealed firearm, even if you have a concealed carry license. There is a case that is pending before the Supreme Court's review right now. It has not yet been heard in conference. It's called Schoenthal versus Raoul. It's a challenge to the ban on public transportation ban on concealed carry in public transportation in the state of Illinois and on the Chicago Transit Authority in particular. The state of Illinois has basically declined to reply to this cert petition unless the Supreme Court directs it to do so, which so far the Supreme Court has not done. The Supreme Court's already taken up one sensitive places case this year, Wolford versus Lopez, with Hawaii's vampire rule. And maybe what they say in Wolford will have implications for cases like Schoenthal versus Rule and sensitive places like public transportation, or sensitive places, quote unquote, like public transportation. But I sure would love to see the court take that particular case, because I think it is not only well outside the national tradition of firearms ownership to prevent people who use public transportation from exercising the right to keep and bear arms, it from a common sense standpoint, it completely violates the spirit of the Second Amendment. Again, the Supreme Court said in Bruin that you can't just describe every crowded public place as sensitive and therefore ban concealed carry. But that's exactly what the Seventh Circuit did in upholding the public transportation ban in Schoenthal versus Raoul. Well, these trains are, crowded tubes, no easy way to get in or out when, the train's underway. And the founding fathers could never have envisioned something like that. So yeah, we can ban guns there. In doing so, you prevent every concealed carry holder who depends on public transportation from carrying throughout the entirety of their day. If they can't carry on a train or a bus, then they can't carry before they get on that train or a bus, because where are they going to put their gun? They can't carry after they get off the train or bus because they don't have their gun with them on the train or the bus. So one gun-free zone leads to a lawful gun owner being disarmed from the time they leave their house until the time they get back home. It renders their concealed carry license utterly useless. Doesn't matter how many places they go throughout the course of their day where concealed carry is allowed. If they're dependent on public transportation to get there, they can't carry. And again, that has such a huge impact, particularly in our biggest cities, that I would love to see the Supreme Court specifically address this issue and grant cert to Schoenthal versus Rule. I hope that they do. Don't know if they will, but fingers crossed. All right, that is going to do it for this edition of Bearing Arms Cam & Company. I want to thank you for being a part of the program. As always, I'm looking forward to seeing you back here again tomorrow for our Hump Day Wednesday edition. Be sure to check out bearingarms.com throughout the day, though we're keeping you up to date on all of the latest Second Amendment information from across the nation. Getting closer to the start of the 2026 legislative session. We are seeing some bills pre-filed. Maybe even seeing a tiny bit of movement in the Florida State Senate when it comes to repealing the state's ban on commercial gun sales to adults under the age of 21. Probably not, but maybe a scintilla of movement from the Senate president there. We've got that story and a whole lot more waiting for you, so be sure to check out bearingarms.com throughout the course of your day and arm yourself with knowledge. When we see you again, we'll be talking more about the news that is impacting your Second Amendment rights. But until then, be well, be safe, and be free.